Good morning, everyone. We'll go ahead and get started. Welcome to the June 8th, 2020 Pennington County Planning Commission meeting. Recommendations of the Planning Commission on certain items from this agenda will be considered by the Board of Commissioners at the regular meeting on June 16th, 2020 at 10:30 a.m. The Planning Commission utilizes speaker request forms, which are available in the Commission chambers during the meeting. With that, we'll be voting on everything via roll call. We'll start off with the roll call. Sorry, Jerry. Or do you need a few minutes?
Rich.
I'm present.
Mark. Oh, we're doing roll call.
Aye.
Jim.
Here.
Sonny.
Here.
Travis.
Here.
Kathy.
Here.
Sandy.
Here.
Okay. Next item on the agenda is the approval of the May 26, 2020 minutes. Did anybody have any changes or corrections to the minutes as written? Seeing none here in the dais. Kathy, any changes?
No.
Jim, any changes?
No.
With that, I entertain a motion for approval of the May 26 minutes.
Move for approval. Second.
Motion and second. Further discussion?
I didn't hear who did the move.
Mark.
Oh,
Mark.
sorry. Thank you.
Seeing no further discussion, vote.
Rich.
Aye.
Mark.
Aye.
Jim.
Aye.
Sonny.
Aye.
Travis.
Aye.
Kathy. Sandy.
Aye.
Motion carries. Next item on the agenda is approval of today's agenda. The consent agenda consists through items 3 through 10 on today's agenda. We have minor planned unit development amendment, item 11 and 12 as regular items, followed by our normal items 13 through 17. Does anyone have any changes to today's agenda? Seeing none here in the dais. Kathy, any changes?
No.
Jim, any changes?
No.
I would entertain a motion for approval.
So moved.
Second.
Motion and second. Further discussion? Seeing none, all those in favor, roll call vote.
Rich.
Aye.
Mark.
Aye.
Jim.
Aye.
Sonny.
Aye.
Travis.
Aye.
Kathy.
Aye.
Sandy.
Aye.
Motion carries. Go ahead. Thank you.
Good morning, Commissioners. Brittany Molitor, Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any Planning Commissioner, staff member, or audience member for separate consideration. The findings of this Planning Commission are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Item number 3 is Conditional Use Permit Review CU 1734 for Sherry Wilkie to review a single-wide mobile home to be used as a permanent single-family residence in a suburban residential district, and staff is recommending approval of the extension of Conditional Use Permit CU 1734 with conditions. Item number 4 is Conditional Use Permit Review CU 1828 for Harry and Gail McCain to review living in the existing residence while building a new single-family residence in a limited agriculture district. Staff is recommending to end Conditional Use Permit CU 1828 with the applicant's concurrence as it is no longer needed. Item number 5 is Conditional Use Permit Review CU 1908 for Jeffrey Scher to live in a recreational vehicle, a camper, while building a single-family residence. Staff is recommending approval of the extension of Conditional Use Permit CU 1908 with conditions. Item number 6 is Conditional Use Permit Review CU 1915 for Samuel G. Fullerton III to review a caretaker's residence on the subject property after a single-family residence is built in a limited agriculture district. Staff is recommending approval of the extension of Conditional Use Permit CU 1915 with conditions. Item number 7 is Conditional Use Permit Review CU 1930 for Harry and Gail McCain to review allowing the existing residence of Morton Building to remain as a guest house once the new single-family residence is complete in a limited agriculture district. Staff is recommending to continue the review of conditional use permit CU 1930 to the June 22nd, 2020 Planning Commission meeting. Item number 8 is conditional use permit review CU 1932 for Jeff and Marcia Spilker to review living in a garage with living quarters while building a single-family residence, and once a single-family residence is habitable, to allow the garage with living quarters to remain and be used as a guest house in a low-density residential district. Staff is recommending approval of the extension of conditional use permit 1932 with conditions. Item number 9 is conditional use permit, conditional use permit CU 20-09 for David and Janelle Gorgon, Jess Island as the agent, to live in the existing double-wide mobile home while building a new single-family residence, and then to allow the existing double-wide mobile home to remain and be converted into a garage with the living quarters removed, or the double-wide mobile home will be removed upon completion of the new single-family residence in a suburban residential district. Staff is recommending approval of conditional use permit CU 20-09 with conditions. And finally, item 10 is road naming for GJ Ranch LLC to name a 24-foot wide access easement providing access to properties in Section 18 and Section 13. And staff is recommending approval of the road naming of White Buffalo Road.
Thank you. Are there any items that staff wishes to pull?
No.
I asked you that earlier. Are there any items the membership wishes to pull from the agenda? Okay. I'll pull item number 10 for the reasons to abstain. For the folks in the audience here, if one of your items is in the consent agenda, and that would be items 3 through 10, if there's any reason that you want to speak on those items to address the commission, we would pull those items from the consent agenda and they get heard separately. If not, then we will vote on all of the items with one vote. Okay. With that, we have items 3 through 9 on today's consent agenda. Is there a motion for approval?
So moved.
Second.
Motion and second. Further discussion? Seeing none, roll call vote.
Rich,
Aye.
Mark,
Aye.
Jim,
Aye.
Sunny,
Aye.
Travis,
Aye.
Kathy,
Aye.
Sandy.
Aye.
Thank you. As I said, I'm abstaining from voting on item number 10, but I have no issues with it. So I would entertain a motion for approval on that.
Move for approval. Second.
Motion and second. Further discussion? Seeing none, roll call vote.
Rich,
Abstain.
Mark,
Aye.
Jim,
Aye.
Sunny,
Aye.
Travis,
Aye.
Kathy,
Aye.
Sandy.
Aye.
Thank you. Brings us to, motion carries, brings us to item 11.
Morning, Commissioners. Jason Thennison, County Planner. Agenda item number 11 is minor planned unit development amendment 20-03 for Lacor LLC. Also Phil Lackner, he's in the audience if you have any questions for him. Site location is on Rushmore Ranch Road, north of the intersection of Highway 40 and Rushmore Ranch Road. The applicant has applied for a minor planned unit development amendment to amend an existing planned unit development to allow a gunsmithing business as a home occupation. As it sits today, the property is zoned planning unit development district consisting of 4.7 acres, a single-family residence, a 32 by 36 equipment building. There's no special flood hazard area, and access is off of Rushmore Ranch Road. The request was sent out for interdepartmental review, and no significant comments were received. Pennington County zoning ordinance defines home occupation as a use conducted entirely within an enclosed structure other than a mobile home, which is clearly incidental and secondary to the residential occupancy and does not change the character of the property. Pennington County's zoning ordinance section 204 states that a customary home occupation is a gainful occupation or profession conducted by members of the immediate family residing on the premises and no more than one additional employee in residential districts. The applicant has stated he will be the only employee that that business associated with the home occupation will be conducted within the 32 by 36 equipment building. Also, that the home occupation will not change the residential character of the subject property. The applicant has also indicated that he has secured a safe and upgraded locks in order to meet Bureau of Alcohol, Tobacco, and Firearms requirements, and will be transferring his federal firearms license to the residential address if this amendment is approved. Home occupations are conditional uses in all other zoning districts except planned unit developments. An approved minor planned unit development amendment will allow the applicant's requested use in this district. Therefore, staff recommends approval of minor planned unit development 20-03 with conditions.
Thank you. Is there any questions for staff on this item? Seeing none here in the dais. Kathy, any questions?
No, not really, but I was just curious about, is this a large PUD or is there just a few homeowners, or is this the only homeowner in the PUD? I just was curious about the kind of the nature of the PUD we're talking about.
That's a rather large PUD up there in the Rushmore Ranch Estates area.
Okay. And how do the other people in the PUD get notices of this? Do they, I mean, obviously it's sent out somehow, and so it kind of helped me understand that.
Right, so at the time of application, the applicant has provided a mailing list of adjacent property owners, and letters are mailed out that way through certified mail.
So it's just to adjacent property owners?
Right, I believe it's within 500 feet.
Not the entire PUD?
It's people within 500 feet.
Okay, I see, all right. And there was no response back from the mailings in terms of people's questions or comments, opposition or anything like that?
No, we didn't receive any comments from anyone.
Okay, thank you.
Okay. Does anyone in the audience wish to speak on this item? Okay. Jim, do you have any questions on this item?
I was kind of curious. Will there be any ammunition stored in this facility or this garage? I mean, of any significant size,
Yes, sir. If you could just state your name for the record when you get up the dais.
Morning. Phil Lochner with Lockor. That is the main gist of the business, is more of load development, custom loads for customers. I do law enforcement, South Dakota Game Fish and Parks previously, and very few firearms. I would say the ammunition is probably 85% of my business and 15% on gunsmithing or firearms repair.
Oh, okay. I'm not certain that large stores of ammunition would ever be a particular hazard other than getting it into the wrong hands. So I was thinking about whether there would be any hazard regarding fire, et cetera,
My requirements on that is the cabinets for the storage of gunpowders and the separation of primers and stuff, meet the OSHA requirements and capacities. Being a small business owner, I am not storing the amounts like what happened to Ultramax in that fashion.
Okay.
Any further questions for the applicant? Okay, thank you, sir.
Thank you.
Sir, are you here to speak on this item as well?
No, I don't know if you're done with mine or not. I was number 9.
So number nine was voted on in the consent agenda, so yes, it was approved. Thank you. No further questions. I would entertain a motion for approval.
Move for approval.
Second. Motion and second. Further discussion. Seeing none, roll call vote.
Rich,
Aye.
Mark,
Aye.
Jim,
Aye.
Sunny,
Aye.
Travis,
Aye.
Catherine. Kathy? Oh, Sandy.
Aye. Motion carries. Brings us to item number 12.
Good morning, Commissioners. Item number 12 is Ordinance Amendment OA 20-02 to amend Section 506 Building Permits to replace and supersede Section 506 Building Permits of the Pennington County zoning ordinance. The purpose of this change is to clarify requirements and procedures for building permit application and submittal. I don't know, Chair, did you want to go page by page and answer questions?
I had the same question that Kathy had with
Okay.
regards to the red lines. I'm curious, what, was it a total rewrite, or are the only items that changed were the comments that were on page 405?
No, it was a complete rewrite. This was the existing, it was just a few paragraphs.
Okay.
Some basic statements. The state's attorney's office and our office worked to basically spell out pretty clearly what our procedure is, the types of requirements, the things that we look at in consideration of building permits. There are some other changes in here, how we review legal nonconforming. There is a notice requirement, the appeal process, some design criteria. So we went
Okay.
through and specifically, I guess, made it more clear essentially in our, how we are actually doing it, we actually put in our ordinance.
Michelle Hoffman, State's Attorney's Office. And one of the big reasons for the overhaul is we're having enforcement issues. The ordinance was so vague, we just really couldn't move forward with enforcement.
Okay. So I would, I guess, open it up if someone has a different suggestion, but considering it's only 5 pages, I think we could just take it as an entire document and go through people's comments as they have them. Does that work for the group? Okay. I read through it. I didn't have anything specific. The only thing that I came up with was the where you're basically defining substantial completion in there, and then you list the document, or you list the definition there from AIA. So I think that's good. That way it sets the expectation in the document for the people using it. But beyond that, I didn't have anything. I'll open it up for anybody else that had any comments or changes to the amendment.
Rich?
Go ahead, Kathy.
Yeah, I'd just like to make sure I understand Section H, the design standards for new construction. And, I remember when we were doing the comprehensive plan, there was some discussion that the county did not have design standards.
We don't.
Construction, and then that was something that needed to be discussed or remedied at some point. And I'm wondering, is this, when I read this, it looks like now there are design standards that will need to be met. Is this different? Is this something, a new requirement compared to what's currently being done? Or is this essentially the same as current?
It is the same as current. We're just actually spelling it out. Statute does require that where it's stated in there where design standards for new construction have not been adopted, because Pennington County does not have building codes, the new construction must comply with the International Building Code that's adopted in SDCL 11-10.
Okay.
And then they are required to get electrical and plumbing inspections. That is on our building permit application, but we're actually stating it, reiterating it here in our ordinance, and the same with the International Fire Code.
Okay, so it's really the same. It's just, you're just articulating it and stating it clearly.
Correct.
Yeah, okay, thank you.
Anybody else? Anything?
Mr. Chairman,
Go ahead, Jim.
let me just say that I think this is a giant step forward in clarity. I always thought this particular section was sort of a mild embarrassment because it was just a kind of a squished together paragraph or series of paragraphs. And the presentation is much better. And the addition of some of these other elements, I think, is most helpful, particularly to people who have to look at the, when they get ready to apply for a building permit. So kudos for having taken care of this. Thank you.
Thank you.
Hey, Jim, is that your dog, Jim?
Yes, it is.
Can
Let me.
You just want to mute your mic?
I'll just mute here, yeah.
Thank you.
Oliver?
Anything else, anybody?
Mr. Chairman,
Go ahead, Travis.
I have a question about D, and maybe I just had an assumption. It says all abutting property owners. Wasn't it supposed to be like 500 feet or something of that nature, or has it always just been abutting?
Michelle Hoffman, State's Attorney's Office. In fact, there's never been a notice requirement.
Okay.
And the reason we've made an effort to insert a notice requirement is because the statutes, applicable statutes dealing with permitting and administrative appeals was recently amended this last state legislative session. But what a lot of people haven't realized is any decisions by the planning director historically and still are appealed to the Board of Adjustment, and we're concerned that property owners will not be able to weigh in on these building permits. We just think it's really important that the property owners have that notice.
So as part of that new Senate bill it was a Senate bill, correct? There is like a 14-day time period. So unless a person is noticed, that time period would run out and their appeal would not be able to be heard. So that was one of the reasons for putting this in here. The previous statute said within a reasonable time. Now it actually states 14 days.
I'll give you an example. So we have building permits that are approved administratively by the planning director. As Ms. Malter pointed out, historically, under that statute, there was an appeal to the Board of Adjustment, still is an appeal to the Board of Adjustment, but it said within a reasonable time period. So if I received a building permit and didn't start building for 2 months, my neighbors aren't going to be aware that I have this permit. So as soon as I start building, maybe there's some erosion problems, some dust problems, they come down and say, what's going on? Well, I don't like that, I want to appeal. Well, now with the 14-day limitation, it's like, well, so sorry, you had 14 days to appeal. Well, I didn't know you granted the permit. So you see, there's the situation where someone could be granted a permit and they wait 14 days to start building, and then the surrounding property owners now no longer have any appeal rights. And I think an appeal right is meaningless unless there's some sort of notice. So we've gone a step beyond the state statutes to require notice at least of the adjoining property owners.
You anticipate any backlash on that requirement?
Backlash from,
Pushback from various people that want to build immediately, because otherwise they'll have to wait 14 days to build.
well,
they could build and be at risk.
exactly. They choose to, well, this actually provides notice. At least the adjoining property owners will have notice before that building permit is even approved, which is the purpose of this, inserting this provision. We're not required to give notice under the statutes, but that's the exact situation we're trying to avoid, at least for the adjoining property owners.
Cool. Thank you. Anything else? Seeing none, I would entertain a motion for approval of the ordinance amendment 20-02. Do you need it to specify anything?
Not unless there's any recommended changes.
Okay.
Mr.
So
Chair,
move for approval.
We have a motion. Sunny spoke first. We'll go ahead with the motion and then pick it up in discussion maybe. So we
Did
have
you
a
want me to second it? or-
no, we have a motion for approval. You can't second the motion. I would need a second. Is there a second?
Are we waiting for a second for approval? Is that it?
We're, yes.
Okay, well, I would provide a second.
All right. Motion and
Now we're
second.
talking.
Further discussion. Go ahead.
Sorry, the cogs were turning when this was discussed just a moment ago. So my understanding then is they have to notify the property owners, but the building permit can't be approved for 14 days. Or
No, the building permit can still go through its regular process, and it can still, as long as it meets our criteria, that's what we look at. If the abutting property owners wanted to appeal my decision of approving or denying that building permit, for whatever reason to the Board of Adjustment, that's the only thing that would do, and then they would have to go to the Board of Adjustment with whatever concerns that they have. But as far as what our office looks at in our approval process and our review process won't change.
so is it possible for a building permit to be approved before all of the abutting property owners have had notification?
The way I believe this is written is someone comes in, and correct me if I'm wrong, Ms. Mulder, but someone comes in and applies for a building permit. It's not going to be approved until they can show that they've mailed the required notices. And I think that's fairly standard with all of our applications. It's not that the building permit is going to be held up. Usually they're handed letters the minute they come in. They're given the addresses, and they just have to show that they mailed them. The benefit of this is that if Ms. Malter approves a building permit and there's an adjoining property owner who takes issue with that building permit, they at least have notice and they'll show up the board, they can appeal to the Board of Adjustment before that 14-day time period expires.
Sounds like a person could want to appeal, but the construction could have already started.
It could, but and we could actually, if there is an appeal, one thing we could add to this is some statement that upon appeal, all construction activity must stop. Basically, and that's very similar to some of the appeals from, say, Board of Adjustment to Circuit Court on certain administrative decisions. So we could put another line in there just basically saying upon appeal, you have to, if you've begun construction, you have to stop.
Mr. Chair,
Go ahead.
I don't think that that's really particularly necessary because I would think that that would be a common sense issue that if a person knows there's somebody appealing their building permit that in a possibility that may be revoked, that they'd continue with their construction. That doesn't, I would think they'd stop without being told you can stop.
They certainly
I mean,
building
to me,
at their
that
own
makes
risk.
sense, but
Yeah, they're building at their own risk.
that's right.
I guess that's what I was gonna go at. They're building at their own risk if they know that it's appealed. So if they continue on, then that's money that that individual's investing that they might lose.
I think we may be seeing this as something that's a long-term project, but what if it was something that could, in theory, be done in one day? Someone could get a building permit, have the project done in one day, within the 14 days, and then the appeal comes after the work is all done.
Well, I can tell you from our office's perspective, once we receive a building permit application, it goes through a review process. So depending upon the nature of the construction, if it's a shed, that's a relatively basic review. But if it's a single-family residence with an on-site wastewater treatment system, it can take up to 7 business days for that review to even go through our office before it even ends up on my desk, depending upon, if it needs an address. I mean, so it could be, that's 14 days could lapse before it even actually gets approved. Does that make sense? Especially if it's a single-family residence on a property, by the time the address is assigned, the on-site wastewater treatment system is inspected and reviewed, and things like that. So typically in our office, we say about 7 to 10 business days for turnaround on a building permit application.
And the
Mr.
appeal
Chairman.
time wouldn't start until the actual date of approval.
Mr.
Go ahead,
Chairman.
Travis.
I was gonna say, Sonny, are you trying to clarify maybe something like a 15 by 15 shed that could be put up pretty quick, so somebody could literally get approval, put it up before even an appeals process go through? Is that kind of what you're talking about?
Yeah, that could be an example. Another could be a distributed solar energy system, which is pretty unique. Somebody could get their permit, install the next day, and then a week later, a neighbor could appeal it. What happens then?
So that appeal would go in front of the Board of Adjustment. So that would be their essential decision for revoking the permit. It would have to be, in my opinion, there would have to be some kind of cause for the Board of Adjustment to revoke it if it wasn't meeting certain requirements. Hopefully, if it's approved by our office, it's met those requirements. So I'm not sure what would be cause for them.
The bottom line is when the planning department reviews, say, a building permit, it should be just a kind of a check the box. Have they met this requirement of the ordinance? Have they met this requirement? And that's why it's an administrative decision versus something that would be heard by the planning commission. And this will never be a perfect system, but the way our ordinances work right now, the building permit is approved, and the way neighbors find out about that is when the construction begins. Well, that wasn't a problem under the old statute because it was just appeal within a reasonable time period. That will be a problem now if building doesn't start after 14 days. And what brought this to my mind is take a CAFO. There's another change within this legislation that allows for special permitted uses as basically allowed with, as long as you meet certain criteria, and there's some discussion that maybe that's the direction our VHRs will go, where it's no longer going to be a matter of something that you hear or decide. It's going to be, here are the conditions of approval, and if you meet these, it gets approved. So it's kind of a hybrid that's recently been approved. But the same thing's going to happen with CAFOs, East River, and that I just foresee a problem because someone's going to come in and complain about that CAFO. If I was the one wanting to build the CAFO, I would wait 14 days till the time of appeal had run, and then I'd start building because I have now kind of laid in the weeds and then start building. So we're just trying to avoid that. We're doing and I don't know a better process outside of just trying to give some sort of notice.
Mr. Chair.
Go ahead.
One item that throughout this discussion has given me a little bit of confusion is what you said a couple of minutes ago, that the 14 days to appeal won't start until the permit is issued.
The decision, yes.
So in other words, then, Brittany, that kind of erases, the decision's already been made, that kind of erases that time period that it takes to make the decision? You know what I'm saying? I mean, you were kind of saying that,
Yes.
well, they're going to have this time to come in and appeal while the decision's being made, but in fact, the 14 days doesn't start until the permit is issued.
The purpose of the notice is just to let the neighbors know this is happening. So independent of what the planning department's decision is on that application, the purpose of this is to let the surrounding neighbors know this is happening. So if the planning department does approve the building permit, this is on their radar if they should choose to appeal once the decision is made.
But wouldn't it make sense then to, I don't know how exactly this would work, but it seems like it would make sense to start that 14-day period upon the time when the person applying for the building permit is given the letters to send to the neighbors.
We can't do that by statute. The statute talks about, the 14-day appeal period starts from the date of the decision. But really, the way I view it, the extra time period it takes for the planning department to review an application is beneficial to the surrounding property owners. That gives them an opportunity to weigh in before the planning department even makes their decision. It not only puts them on notice for a potential appeal, but because they're going to get these letters most likely before planning department has even approved most of these building permits. So it gives them opportunity to weigh in before, and also gives them opportunity to appeal after a decision.
Okay.
Mr. Chairman.
Go ahead, Travis.
So unless I missed it reading in here, it's an administrative decision, correct?
Yes.
So how are the individuals that are butting next to the property going to know that it was approved or disapproved? How are they going to know that if it's just an administrative decision?
That's the purpose of the letter.
So there's going to be
When-
another letter that'll say that,
No,
oh,
they'll
okay.
receive a letter that this application's been made. There's a certain responsibility on the property owners if they have concern about the proposed building activity to reach out to the planning department or determine what the planning department's ultimate decision was. But that's much better than them getting no notice.
I'm sensing the conversation, and I can sense a scenario where, what if the two neighbors just don't get along and the other neighbor appeals just because maybe doesn't have any issues with it or something like that. I mean, we've seen a few of those things here over the past year. But the alternate is that it just goes up and no one knew anything about it, and then they come and complain that, hey, we didn't even know anything about this. How does this just happen without any sort of notice? So, I guess in my mind, I think the notice is a good thing, but this is an administrative decision. If they're meeting all of the criteria, I'm not sure if they appeal that to the Board of Adjustment, what the Board of Adjustment would do. How often do your building permit applications get turned around?
What do you mean, how often?
How often have you approved a building permit only for the board to come in and say, we're going to do this instead?
The only building permit I think that has been in front of the Board of Adjustment was a few building permits on Bradsky Road, and it had to do with the number of lots over the 40
Okay.
because of one means of ingress and egress. Those are the only ones off the top of my head that I can think of that have actually been in front of the Board
Okay.
of Adjustment.
All I can think of in the last 4 years.
One of the debates we had was an issue that's already been raised is, should the notification area be larger? Since it's building permit, we decided building permits was appropriate just to do adjoining property owners. But that's really more of a legislative decision by you and the board.
I would be not in favor of making the area larger. I mean, frankly, this is putting a little bit of a, maybe an undue burden on the person that, like, for example, if they're just simply putting in solar that isn't going to interfere with their neighbor in any way, shape, or form, except for maybe some reflection, I guess, that could happen. But if they're putting in a 15 by 15 foot shed and they're following all of the parameters that we require, I almost feel like it's none of the neighbor's business.
Well, that's why
what we're doing.
For that reason, we decided on adjacent property owners. We were trying to strike a balance between giving proper notice to neighbors, but not making it unduly burdensome to the applicant.
No.
Mr. Chairman,
Go ahead, Jim.
excuse me. Is there some criteria upon which one can make an objection? In other words, it seems to me that what are the grounds or the criteria for making an objection on a building permit? Is it simply that the administrative requirements have not been met or have been somehow distorted or whatever? I'm just wondering.
I think that could be one challenge. Trust me, lawyers are creative when they approach these cases. And I was in litigation for years, so I understand that. So that would be one objection. I really think probably the only other basis that might be successful, if there was a true public nuisance that was being created, or that there was in fact some real threat to the public health, welfare, or safety. But if all these criteria are met and they're not truly infringing on the adjoining property owner's use of their own property, I think the type of challenges that would be available here would be very limited. I think, if there was noise complaint but this should be very finite. So have they changed? Maybe that would be a good example. I could see an example where someone modified the train such that the drainage was altered. That's a problem. And so I could see that being a legitimate challenge. But I think potential challenges to this will be fairly limited. I think our idea too is we're rewriting numerous statutes. I've now almost completed a complete rewrite of our conditional use permit ordinance. The idea is not to draft these and then forget about them, which I think has happened, again, historically in the past. As we implement these new ordinances, we really want to monitor how they're working in real life. So if we start seeing an issue with the application of this ordinance, the idea would be to come in and amend it immediately. Sometimes it's hard to know what the fallout might be, of a new piece of legislation without seeing it in action. So we certainly are not going to just draft this, pass it, and shelve it.
Mr. Chairman?
Hold on, Jim. Go ahead, Sonny.
Oh, okay.
I'll just to wrap up my comment, I think it's good discussion. I don't think the appeal situation is likely and all that, but there's apparently some potential for something like that. And I can see maybe the bigger issue is in the mind of the contractor or the person applying for the building permit. They're now going to have to count days just in case, and there's a potential burden there. I don't know what the fix to that is, but at the same time, I do think the idea here is sound.
Go ahead, Jim.
I need to be clarified on one thing. One of the things that Brittany mentioned was the process of providing the permit and doing the planning work necessary to come to a conclusion that this took 7 to 10 days and so forth. And that probably the first step is to give the people the letter, and that in essence what would happen is that the 14-day period and the 10-day period or whatever would be very, very close. In other words, making it almost the 14-day period not an impediment, it doesn't seem. But, is that what you were speaking to, Brittany?
I was, I think, like I said, with the 7 to 10 days review, typically if there's a concern, I think our office would hear about it prior to that 14 days actually starting. That would give us an opportunity to work it out or whatever concerns that there would be prior to that appeal period starting. In the event that someone is not satisfied with our office's decision, they could ultimately take it to the Board of Adjustment. Just historically, I don't see there being a large amount of building permits being appealed to the Board of Adjustment. I believe that once that notice, there'll be phone calls to our office. I think most of the concerns could be vetted out prior to that 14 days even starting. Does that make sense?
And it also, again, as Ms. Malter stated, it allows, sending out those letters allows property owners to contact her and weigh in with their concerns before decisions even made, which is not something we currently have in the process we're employing today.
Mr. Chair.
Go ahead.
So right now, currently, if we're putting up a 15 by 15 foot shed, we're not required to notify anybody at this point in time. See, that's my biggest concern about this. And I understand where you guys are coming from, that we sometimes have, I've had them here, after the fact, come in and start complaining, well, this guy built this big monolith of a whatever. But I'm worried that we're going to be, as you said there a while back, what if you got these neighbors that are just constant complainers that don't like this particular neighbor. And whatever he does, it's kind of like the deal that we dealt with up off of 385 there with the event center, where you just have people that just don't like those people. So they're just going to come in and complain because they just don't like those people. And then it's going to hold up that particular person until the appeal process is done, which is, to me, unfair. If I want to put up my 15-foot by 15-foot shed on the back right corner of my property, and it's not creating any issues, like you said, with runoff, and it's meeting and conforming with everything that planning and zoning asks for, I don't know if I necessarily should have to tell my neighbor I'm putting up a 15 by 15-foot shed. I mean, like I said, frankly, it's really none of his business. Unless I'm impeding, well, I can't think of where that would be the case, where I'd be impeding his movement from his yard to somewhere else. I don't know. Just, I'm feeling like this is putting an undue burden on the builder.
Again, it's a balance, because the flip side of that, that's the more benign, and we can all come up with examples where they're not, it's maybe a building permit that results in something not so benign. And I could easily see, and I foresee arguments down the road as these administrative decisions are made across the state and someone didn't have notice of that decision, where there's going to be litigation because other property owners weren't given notice. They weren't given due process to be able to be heard. And in that instance, I mean, we deal on a daily basis with those types of situations. And I think we, as employees of county, approach them very fairly. And in those, you're right, they would most likely in that case it would be approved, and that neighbor could appeal. And so there's that 14-day time period. But in looking at that, I trust also the Board of Adjustment to kind of be able to, I don't know that it doesn't hold up the person who's constructing. That's completely up to them if they want to continue to construct that shed or place that shed. But I also trust the Board of Adjustment to also be able to flesh out those occasional cases.
But I would say, Michelle, that if it was me personally, and I knew that somebody had appealed, I wouldn't be spending any more money on that project till I knew that it was going to pass that Board of Appeal. I mean, to me, that wouldn't make sense. But even if the chances are slim that it's going to get revoked.
Well, I think that's what the legislature put into place, this 14 days as well. They wanted to really prevent some of this litigation in the appeal process from taking years. I think that's why they put the 14-day limit in.
Mr. Chairman,
Go ahead, Jim.
I just want to make the observation that it seems to me that while it would seem ludicrous that someone would oppose a 15 by 15 foot, shed or whatever, or for all practical purposes, the installation of solar panels. I think what we're looking for here is projects which imply a much greater objection. I mean, some people might complain about a 15 by 15 foot shed. That's very possible. But I suspect that the majority of objections will be based on projects of more consequence. And as a consequence, I don't think it's going to affect most of the average size projects when people build a garage or they do whatever. And we're writing a statute that is trying to appeal to or trying to address all of these projects, the nature of them almost inconsequential to the gargantuan. And somehow the process is going to be a little imperfect, it seems to me, on one end of the spectrum or the other. I don't see a lot of difficulty here, except, if somebody has a building permit for a major sort of construction that, and once again, in my own mind, I'm not so certain what the criteria for opposition is going to be and how they would be able to sustain their complaint. That to me is still unclear. So in any event, I think we may be making perhaps too much out of this, at least in my mind.
Well, I think too, if you look at a application review, maybe an argument would be that it doesn't meet the specifications in the application, which would be a fair objection, as well as applicable state, local, state, and federal law, rules, and regulations, which people should be complying with in any event. Same thing, the building has to comply, again, with local, state, federal law. You can't be building something within encroachment or an area or easement. I mean, those are really going to be your primary objections, as well as if it's infringing on a neighbor's use and enjoyment of their own property. But that's pretty much going to be the basis for any challenges, so it's going to be fairly limited.
The one question I have is, South Dakota Codified Law 11255, does it actually, it says as prescribed under that codified law, or getting back to one of Jim's points earlier, are there criteria within that for the appeal, or does it just say that you can appeal
It's just that you can appeal.
for whatever reason?
Is that an agreed standard?
They may have, I'd have to go back and look at that. That is also part of the recent legislation, and I'm not sure if it only applies to conditional use permits or not. This is not a conditional use. Appeal of conditional use permits now are reviewed under aggrieved status, and that's per state statute now. We don't have any discretion as a county with that regard. I'm not sure whether that aggrieved standard would apply to administrative decisions. I'd have to go back and look at the ordinance. But in terms of being able to appeal, it's just a matter, as far as board adjustment, I think the only way they could overturn the planning department's decision is if on a vote of 3-2, they believe that the criteria in our ordinance has not been met.
54. It's a supermajority for a Board of
Oh,
Adjustment.
that's true, yeah. Thank you. Yeah, I'm thinking, well, it's a supermajority for
Board of Adjustment.
variances. I'm not sure. I'd have to go back and look at that. It's a supermajority for variances. I'm not sure that it's a supermajority, but it most likely is for these appeals as well. So that would be another protection for the applicant. If it's a supermajority, it's going to be pretty hard to overcome that criteria. The person who's appealing is going to have to persuade 4 of the 5 Board of Adjustment members to reverse the planning director.
Okay,
Mr. Chairman?
go ahead, Travis.
Quick question, and this one just came to mind as I'm reading through this and kind of going over it a couple of times. So maybe walk me through the process unless I missed it here. Since it's an administrative approval, is there a time frame from when the planning director has to approve it? So in other words, once the application's complete and then it's heard by the planning commission, then it has to be approved once we hear it and public comment is available, or how is that going to work? Is there, I guess, I want to know, is there going to be a time frame so that the person who's doing the project knows that after this date, it should be stamped with their signature? Does that make sense? Am I asking the question right?
Right, so if someone wanted to appeal a decision of the planning director, they would do their appeal. Typically, our office would put it on the next agenda, pursuant to any kind of notice that we would have to do in the newspapers. So that typically is what gauges when something would be on the agenda. Like in a conditional use permit, we have to notice so many times, and I don't think for an appeal, it's just getting on the agenda the next.
The Board of
It
Adjustment.
goes straight onto the next.
Board of Adjustment
Board of Adjustment.
calendar. There's nothing in the statute that requires this notice, and we're not requiring a 10-day notice. So that's the other thing too. As soon as there's an appeal, the very next board meeting, it would be placed on the Board of Adjustments on a
Okay,
calendar.
let's say there's no appeal, and the process goes through, the individual turns in everything. Is there a time frame that the planning director has to sign it once the application is complete? In other words, under E8, it says a building permit is not approved until the application has been signed and stamped approved by the planning director or designee. When does that particular action happen?
It's typically 7 to 10 business days. And that was one of the reasons, if you look, expiration of building permit,
Where's that at?
on page 4 of 5, item I. There are building permits in our office that we have been asking for additional information in order to approve because we don't have an expiration. Now, I believe it's under that one. And then where's the other? The incomplete under item C, the last paragraph, an incomplete building permit, now they'll automatically be denied. Because right now, we can ask for further information upon review. Some, various staff members review these building permit applications and we will ask for additional information from the applicant. If we don't get it, it just sits and we wait and we wait. Because we don't have anything in our ordinance that allows us to deny or anything, so they just sit and wait for additional information. Now, we have the 90-day period. If they don't submit all the applicable information or information that we request to approve the building permit, it'll automatically be denied and they'll have to reapply.
Right. But let's say I meet all the criteria, application requirements, and I've given everything over to the planning. Is there a time frame from the moment I give you everything that you need, the planning department, and then the time that the director has to sign the permit? Is there,
Not a time. We give a rough 7 to 10 business days. We try to get things out as soon as possible for the applicants once we receive a completed application and we go through the process.
Mr. Chair.
Go ahead, Travis, or Sunny.
So if we're thinking of projects where ground's being broken and foundations and, things that will take weeks, real building projects, I see this as all good, but I'm still concerned about these smaller projects, add to the things we talked about, a 9-foot fence, a retaining wall, things that are pretty routine. And there's no reason someone should appeal or be denied that building permit. But when a neighbor gets a notification, I feel like the potential is there for a nuisance appeal of somebody who thinks that they have to act on this or find it worrying. And then the appeal process could, I imagine, add weeks that a contractor could be waiting to be sure that they're okay to move forward. So that makes me wonder, and I don't know if this is possible, but is there a way to distinguish between types of projects to say this or that project would require notification, others wouldn't?
We actually discussed that issue thoroughly with regard to the stormwater ordinance, and my concern is inequitable application of the law and challenges that might be made under equal protection argument, because just because we might view that appeal as a nuisance, I don't know that we're really in a place to make that judgment, and I don't know that based upon the size or the value of the building, that really gives us an illegal basis to provide less notice to adjoining property owners than in other cases. So we discussed that quite a bit, because under that stormwater permit, we initially were breaking apart the notice requirements depending whether it was small scale or large scale. And we were fearful that would create a legal problem, inequitable application of standards.
I thought that might be the case. Well, given the discussion we've just had, I'm wondering if any new thoughts or ideas would justify that we continue this, if there's any possible edits or improvements you think you could make?
The only one, and I think there's a disagreement on the commission, the only one that comes to my mind is putting in something about the fact that there's a stay on the construction, but then that's a double-edged sword. It protects the property owner from not, it makes them stop, and I think we thought it's better for them that's their decision, especially if it's just a shed. They probably can move the shed to a different location. If there's really an issue, there's probably not an issue. So that's the only thing that came to my mind, but I don't know that we want to further interfere with property owners' use of their property. So I can't think of any way to make this better. It's not going to be perfect. It's just a kind of trying to balance everyone's interests.
Mr. Chairman,
Go ahead.
You know, the more I think about this thing, the less utility I see in it. I really don't see, we prescribe to some extent, to a large extent, what is going to happen on a piece of property when we zone it. Land use possibilities. We provide for a conditional use permit of some kind, which is a process. And I'm trying to think in my own mind, what would be the objection if someone's going to build a garage or something like that on their property that would be justifiable in imposing this kind of additional consideration period, which is kind of what it is. I mean, the only thing I can think of, and now nuisance was mentioned, which is a vague, very difficult term to define. We're constantly wrestling with nuisance because we can't really define it. It's really in the eye of the beholder. So it seems to me that's what oftentimes the objection would be that they're doing something that the neighbor just doesn't like the looks of it or something like that. Or if it's not consistent with the usage of the property, but it seems to me that should become clear during the permitting process.
Correct.
I'm not sure that this particular provision is even necessary.
Well, we're actually not imposing any additional time period. I think maybe what's getting lost is the 14 days is starting July 1st is imposed by statute. That is pursuant to statute. So this ordinance is not adding 14 days to the process. All we're doing is providing some notice to adjoining property owners because, again, I think it leads us down the road, and maybe it doesn't happen for 5 years. But there's the potential to a property owner coming in saying, I don't like this, I want to appeal. Sorry, 14 days is run, you have no further appeal rights. Well, how could I appeal when I didn't have any notice? You violated my due process rights. So that's all this is doing. We're not adding 14 days to anything. The state legislature put that finite 14 days. Actually, under the old statute, it was an unlimited amount of time for an appeal. And that's why we didn't require notice, because under the old statute, it was just a reasonable time. So someone could come in 3 months later, and if the construction had just started, that would be reasonable for them to come in 3 months later and file an appeal with the Board of Adjustment. But with the 14 days, we just see situations where there's going to be construction after that 14-day period, and there's no appeal rights. So basically, we're trying to make sure property owners still really have at least some sort of appeal rights.
Well, I understand that, and I appreciate what you're saying, but I still don't see the necessity of this provision of notice, but that may be above my pay grade. I don't know.
Well, maybe it would be helpful for a real-life situation. Someone's building a huge garage, multi-car garage, and it's actually probably going to, and forget the nature of whether it's going to be used for residential or commercial. We see those arguments all the time. But there may be issues with the size of that structure. It's allowed under our ordinances. We issue a building permit. Under the current statute, again, the new legislation doesn't go into effect till July 1st. Under the current statute, maybe I don't start building this monstrosity for 3 months. My neighbor sees it, they come in and say, what's going on? Well, we issued a building permit. Well, I want to appeal this. I don't like this. They could appeal because under the current statute, it's a reasonable time period. And I would argue that if the building just started and you came in within a few weeks of the building, that's probably reasonable. Under the statute that's going to go into effect July 1st, same scenario, building starts 3 months after the building permit's approved. Neighbor doesn't like it, comes in and complains. We say, sorry, you have no appeal rights. You only had 14 days to appeal from the date of Ms. Molitor's decision. They have no their only recourse will be to sue the county and argue we violated their due process rights. So it's ultimately it's the commission and the Board of Commissioners' decision, but we were just trying to look at the potential pitfalls in terms of the new 14-day requirement that the state legislature put into place with regard to all administrative decisions.
Okay, I just don't want to be in a position to try and, for all practical purposes, administer or legislate against bad taste. I mean, because that's sometimes what it comes down to. Somebody builds it according to the specs and the limitations and possibilities of the zoning of the property, and the neighbor doesn't like it because it's too big. Well, I grant you, I'd probably be the first one lined up saying it's too big, it's ugly. But I don't want us to get in a situation where we're trying to legislate something that for all practical purposes, we're not gonna have any success at.
And I'm not
But on the other
suggesting,
hand-
oh, I'm sorry.
Go ahead.
I was just going to say, I'm not suggesting, that's probably not the perfect example, it's just trying to give you an example. Under that scenario, I don't see any basis for denying that permit, nor do I see any basis for the Board of Adjustment overturning the planning director's decision. If they've met the requirements, they get their permit, period.
Mr. Chair.
Go ahead.
Jim, to Michelle's point, this 14 days is actually protecting the builder the way that I'm seeing it. However, I don't think in my opinion, humble opinion, the builder doesn't need any protection because he's met all requirements of our permitting process. And therefore, if I'm thinking of this correctly, Michelle, how do we in any way violate due process when they really don't have a leg to stand on in the first place?
Well, the
If
statute.
if the builder has met all requirements and our planning department has checked off dotted all the i's and crossed all the t's, then that next door neighbor doesn't really have
Well,
the option of due process in my.
I agree with you. In Pennington County with Ms. Molitor as our planning director, she's going to follow our requirements and she's going to follow them quite strictly. But we all know of cases where there's been abuse of administrative decisions. It just happens, and that's what the rules are there for. They're for that instance where, and I'm not saying it would happen here, but it does happen. Either a mistake is made, or maybe someone's, politics, someone's greasing the wheel, so to speak, or they're friends, or there's certain connections there. I think we're talking about something that's not going to happen very often. And certainly, again, this was just it's going to be imperfect. We did this so it was the least restrictive to the builder. And most of the problems have happened, all this legislation that came down was in response to CAFOs in East River being held up by extensive litigation. I don't think we're going to have that here, but again, I just think an appeal right is meaningless if I don't have some sort of notice that I have that right to appeal.
Mr. Chairman.
Go ahead, Travis.
Aren't these public notice, though? I mean, is there like a publication, public notice or anything on any of these? None at all? Even our publishing the agenda and stuff doesn't count as public notice if it's listed on there?
You're never going to see these. They're administrative decisions by the planning director.
Yeah, the only things that are public notice are something that's different than what our ordinance allows. So a conditional use is essentially a variance to an allowed use, essentially. So a conditional use is something that's not a permitted use, it's a conditional use. Those are something that aren't typically permitted in those zoning districts. That's why there's a hearing, there's notice, things like that. Same with the variance that the Board of Adjustment hears. This is just, and Michelle and I talked about this, our staff has talked about this, having the same conversations that we're having on this. It just comes down to the fact that protecting the county from potential litigation for a due process issue. That's essentially what we're trying to prevent from happening. In the event that there are neighbors, this is similar to the one in 385, that they felt like they should have a voice or a say in a construction process, they don't get that voice. So instead, they litigate against the county, saying that they weren't given a right to even appeal or have a say. So that's kind of, like I said, staff and the SAO, we've talked about this. We've had these same conversations that are happening right now amongst ourselves, trying to figure out what's best moving forward.
That's why we came down to just adjoining property owners. We were trying to make it as least restrictive as possible. Usually going to be 4 letters.
I appreciate all the conversation, and I think that it's really good. I've come down to similar to the way Mark's thinking about this. This is really going to protect the landowner, property owner, contractor, whoever is going through this process. The flip side to this is that people will get notice who may, and the question is whether that additional notice is going to prompt any additional response that maybe wouldn't have come if they didn't get notice. But I really like the idea of limiting the recourse so they don't decide they don't like something 4 months down the road. And that in my mind is a bigger exposure than 14 days. It doesn't solve the issue that Sonny's bringing up, though, however, with the short time frame and installs. I think I'm on board with the notice requirements, given the 14 days and how they go through it. But I would say that I would hope that the Board of Appeal would look at this, understand that they met all of the requirements for the application, and that's what prompted the question about the appeal. Like they just get to appeal. There's no I'm appealing for these 5 reasons, and you. So in my mind, there's almost like this switch of power to the adjacent landowner from the property owner in that instance. And I don't know if I necessarily am in favor of that, but if they're going to appeal, they're going to appeal.
And
That's kind of
also,
the way I see it.
I think Ms. Malter is correct. I was trying to kind of reconstruct the statute in my head. It's been a few months since I've looked at it, but conditional uses have a different voting requirement by statute. They only require a majority, but I believe that all administrative decisions would be decided under a supermajority before the Board of Adjustment. And then any appeal from there is very restricted under a writ of certiorari. So the whole process is designed to eliminate unnecessary appeals and an unreasonable overturning of the planning director's decision.
Mr. Chair.
Go ahead, Sonny.
So we got different concerns, but, back to the one I'm thinking in summary, it's what I would just call a nuisance appeal. Somebody gets this letter and it kind of triggers them and they feel like they have to act on it. And if we could somehow have a way that they could not be alarmed by it, maybe it's the language that's used, the way it's written, or a way to have their concerns addressed before they go to the appeal process, perhaps we could avoid the possible nuisance that it could cause. It's one thing that I think maybe it's just the notification letter that.
I think that's actually, in another way, you can look at that way, that letter does protect the contractor, because those, again, that letter should go out immediately. And maybe that's one thing we could change, is to make this better, make it very clear, not just that your permit won't be approved until you show us proof of the letters, but they have to go out immediately. And that gives more time period for the planning department to consider any objections and hopefully resolve them.
Yeah, but what I mean is, so the neighboring landowner gets this letter, and what do they see? How does it? I've never seen one of these notifications. What does it look like to them? Will it prompt them to feel like they need to act? They only have 14 days. I better do something. Or is it going to say, if you have any questions or concerns, first contact, and then maybe the planning staff could address their concerns and explain things to them so that they don't jump to an appeal?
Correct, and we haven't drafted that letter yet because obviously we don't, that would be a policy issue within our office. We have spoken about it, and it would be pretty simple that this is just a notice to let you know that this property, you know, given an address, is building a 40 by 60 garage building. If you have any questions or concerns, please contact the planning office at, I think it would be very basic. And then at that time, you know, when they call the office, I mean, we get a few calls here and there. But in all honesty, I mean, even you guys see with notices with conditional use permits, how many people actually come and voice, you know, concerns. I see it very similarly. We issue, you know, anywhere from 50 to 100 permits a month. I would venture to guess we might get calls on maybe one or two. So I'm not certain that you will hear about that many of them. Typically, the ones that we hear about are very large structures, people concerned that it may block their view, things like that. Some of the concerns we could see is if there's a line of sight issue, you know, things like that, that may be addressed internally. But if we, you know, don't have something in our ordinance that prevents them from doing it, it would be difficult for our office to prevent them from. Hence, they would have to go to the Board of Adjustment because they would be the only ones that could tell us that we couldn't issue the building permit based on some extra existential situation. Those are just the type of things that, in my mind, I could see something that we wouldn't necessarily realize. We look at a piece of paper, we don't go out to the site because we don't have building inspectors right now, so we wouldn't necessarily, just because you meet a 25-foot setback, you may be blocking a line of sight or something like that that we may not see. Just from the general review, so that might be something that would come up, that may warrant some kind of investigation by our office or a site visit.
And we discussed that exact issue. Do you give notice of the application or do you give notice of the decision? We thought it was better to give notice of the application, so if there was any objection, they could be heard prior to the decision-making process versus sending out a letter of the decision and saying, oh, you have X days to appeal. That's going to maybe more invite the litigation or the appeal that I think is of concern of the commission here versus sending out notice of just the application and if anyone has any comments or concerns to call.
Mr. Chair.
Go ahead.
I think my biggest concern with this is that it's going to, that our constituents are going to look at this as more government control. And that it is possible that it's going to maybe open up a can of worms that wouldn't have been opened in the first place. Those are my two biggest concerns. I'm positive that at least the constituents that I speak with often that reflect my decisions back at me all the time would be telling me you just allowed more control. And so that's where I probably would have to draw my line.
I guess, and I understand that, and I guess the response, and again, ultimately, this is the commission's decision. I would just weigh in with the fact that actually we're not exercising more control.
I know.
Yeah, the appeal
But it's
process was there,
appearance.
yeah. Then the flip side is going to be there'll be constituents who are unhappy, maybe because they don't like their neighbor is, you took my voice away. So it's never going to be a perfect system. It's ultimately your decision. And I appreciate this conversation because as Ms. Molitor mentioned, we had all the same debates and discussions as we were drafting the ordinance.
Mr. Chairman.
Go ahead, Travis.
And I'm torn on it too, because right now the process is what? If I want to put that shed in there, I go apply for the building permit, put the shed in there, and my neighbor doesn't know that unless he sees me building, right? I get
Yeah.
it, July 1st, things are changing from the state's perspective because our legislators change things. Trust me, that's why I said I'm torn, because I'm like, well, I could go build my shed now. I come apply for my permit. You give me my permit, I go do it. My neighbor is none the wiser, unless he doesn't like it because I put a pink roof on it or something. I don't know. But you're right. Now the state kind of has boxed us into saying, well, all these appeals are 14 days out, or you only have 14 days to appeal. Did they give a, I mean, I noticed we decided, or you guys decided it's based on notice. Is the state determine whether it's notice or that it's issued? Is there
It's
any
the date of,
clarification in there?
it's the date of the decision, and there's no notice requirement. In fact, as this, on the eve, Jack Heeb, who also does a lot of work for Aberdeen and Brown County, in this regard, we had several discussions as he was driving to Pier to try and clean up some other problems with the legislation. And we both had this discussion as well, as the problem is, in administrative decisions, no one's going to ever have notice that the decisions are made. And that wasn't a problem previously until it became a problem. Now, when it becomes a problem, the pill time for appeal's gone. So, yeah, it's not going to be perfect. We appreciate your concerns, and certainly you're free to strike that language. We're just trying to do the best we can to strike a balance.
And, you know, like I said, staff has talked about this. There was some staff that were in the position like that this is too much. You know, now you're expecting everybody to notice. But we just wanted the commission and the board to be aware of the new legislation going into effect July 1st and be cognizant of the potential, you know, if we choose not to have this in there, what could be the argument in the future, just putting all the information out there and letting the commission and the board make that decision.
And again, if either way we go, if there is an issue, we can amend our ordinance. The notice requirement, there's no notice requirement under the statute right now, and that's what's interesting. Yet.
Further discussion? Seeing none, hearing none. Motion is for approval, and I think that we're at a roll call vote.
Rich,
Aye.
Mark,
Nay.
Jim,
No.
Sunny,
Aye.
Travis,
No.
Kathy,
Aye.
Sandy.
Aye.
Motion carries 4 to 3.
3.
Correct. Good discussion.
Good discussion.
And if, you know, this obviously is only a recommendation to the Board of Commissioners. If any of you have, between now and when the board considers any further thoughts, a way that we can make this better, we would very much entertain them.
I'll be thinking about it.
I think you've done the best you can with, given what legislators have done. But, you know, from the point of view that I was speaking towards, I think it's now in the hands of the planning department to see that these neighboring properties don't have unjustified complaints, and that they understand if a building permit is approved because everything's right, that hopefully they won't create appeals and slow down contractors' work unnecessarily in whatever way you can.
Yes. Or the board could remove that portion.
No, it's excellent, excellent
so-
discussion. We're
Yeah.
just kind of chuckling because we had all the same discussions and back and forth. So.
I mean, don't get me wrong. I think it's good. In some ways, I do think it's good to let them know now that there is this, because there is a finite time that you have to do your appeal. Before, you're right. There was no time frame.
That's the only reason for this.
And I get it, but I'm just like, man, I got to think about this. There has to be another way to do something with this. I don't know. That's what's going in my head. There's got to be another way, maybe. That's
And-
why I know, so I can maybe think about it. I don't know.
I recently made this statement, and this applies here. I don't care about being right. I just want to do the right thing. So that's why I really appreciate these discussions and questions. And if you can think of something that we haven't thought about, we really welcome it, because we only want to make it better.
I don't know if there is. I mean, in order to have the due process, they have to have the time. So you're either going to back up someone and allow them to appeal something that you haven't even decided on, or you have to decide on it and allow them the time frame to appeal afterwards. So I ran through some of those scenarios in my head trying to listen to this to see if there was a solution there. I like the fact that it puts an end date on whatever the decision is, up or down. You get to appeal, you don't like the decision, you appeal, it goes to another board, done. So I think that that's a good thing, whatever the issue is.
Yeah,
So things have to move forward.
Mr. Chairman, and maybe we didn't ask this, I don't think any of us did. Does that mean the appeal has to be completely, what's the word I'm looking for? Adjudicated or whatever, my brain just dumped the word that was in my brain. But does it, within that 14 days, does the appeal have to be done? Or is it that's just starting the appeal process, and then there may be multiple hearings that could go on? I don't assume that that's going to happen in hardly any cases, but if there was a big one that maybe there was a lot of questions on, or does it have to all be done within that 14-day period?
No, it just, they have to file notice of
Has to
appeal
be
within
just
that
file a
14
notice.
days, but arguably, if they file,
On day 14.
yeah, but again, it's going to go on the Board of Adjustments calendar, the very next hearing date. And so, yeah.
And typically in our office, and Jerry can attest to this, we'll get an email that says, I want to appeal this decision. I mean, it's as basic as that. And then it gets put on calendar. And then once the packets are made, they will bring in information that substantiates their appeal, and then they'll provide testimony during that hearing. So,
Once it goes on Board of Adjustment, though, then it's noticed in the paper. And then the rest of the neighborhood knows
Well,
about it.
the appeal isn't in the paper, it's just on the agenda.
Yeah, it's not in
Oh,
the
okay,
paper.
okay.
Yeah, those are, there's no required publication
Okay.
notice.
Okay. Let's move forward. County Board Report, item 13.
Thank you.
Item 13, the Board of Commissioners concurred with the Planning Commission's recommendations from the May 26, 2020 Planning Commission meeting.
Thank you. Seeing no items from the public, we will move forward past 14. Items from staff, the building permit report.
The building permit report, we did issue 71 permits in May. We are up in several categories. We have been receiving building permits. It's business as usual, even with the COVID challenges. We've been getting several emails a day with building permits, people submitting electronically in our Dropbox. So we haven't seen too much of a downturn.
Brittany,
Office.
are we getting many complaints that things are too difficult to get into the planning?
I personally haven't heard too many. I think that everybody has been considering the situation pretty amenable, and
Good.
I think people are kind of adjusting. Our office did start taking credit cards about 3 to 4 weeks ago, and it has been pretty successful. I think that's definitely an avenue for people, and it's easier for them to pay. Even though there is a surcharge on it, it's definitely a convenience for the public, especially during this, and I see it continuing on. And like I said, I think some of the builders and some of the contractors, the engineers, I think they actually prefer to submit via email than coming down, and I see that staying as a common.
Saves them time.
So I see that continuing, moving forward. So that's something our office is looking at, creating fillable forms and more convenience online for that. Because I see even after all of this, seeing those, the contractors and the engineers continuing to do things electronically.
Good deal.
The only item that I saw that I had a question on was May 2019 and May of 2020. That's the exact same dollar amount, $1.82 million. I didn't know if that was the same for public works and utilities. Item
Yes, that might be.
324 CO. don't know if it was just entered twice or what happened there.
Yes.
Okay.
I believe that's actually from this year because that was from Black Hills Corp. They did do a new substation, so that was from theirs for this year. It shouldn't be in 19. It should just
Okay.
be in 2020.
So then really, the dollar amounts probably are going to be fairly close because no, never mind. 2019
Will
doesn't
actually be
include it.
2020 will actually be higher.
Yeah, okay. Further questions on the building permit report? Okay. Does staff have any other items? Okay. Items from the membership, item 16. Seeing none. Jim or
Move to
Kathy?
adjourn.
Do you guys have anything, Jim or Kathy?
No, I don't.
Nothing here.
All right. We had a motion for an adjournment.
Second.
Motion and second. Further discussion? Seeing none, roll call vote.
Rich,
Aye.
Mark,
Aye.
Jim,
Aye.
Sunny,
Aye.
Travis.
Aye.
Kathy,
Aye.
Sandy.
Aye.
We're adjourned. Thank you, everyone.